Good evening, everyone. For those who don't know me, I'm Lara Deeb, this year's director for the Humanities Institute and a faculty member here in anthropology and Middle East studies. It's probably an understatement to say that it's been a bad week, and I'm glad to see you all here for the penultimate lecture for this fall in our series, a lecture by Professor Lisa Hajjar about the legacy of American torture, which is sadly very timely as the president-elect has reconfirmed his commitment to waterboarding just this morning. Today's event is part of our series that looks critically at the past 15 years of the so-called War on Terror. One of the goals of this series has been to assess some of the consequences of this global US war for people living both in and outside the United States. And this week is an especially important moment for that sort of assessment. Our next and final event for the fall series will be on December 1st, when Zarina Grewal will talk about the Quran in the American imagination. And I also want to call your attention to an event we're co-sponsoring this Monday, where it's called 6 Women in Struggles for Turtle Island, and 6 indigenous activists will be talking about Tierra y Dignidad from Mexico to the Dakota, Minnesota homeland, standing with Standing Rock. And that will be in this room at 6 o'clock on Monday evening, and there's flyers in the back. And let's see, as always, if you don't get email from us and would like to, there's a sign-up sheet for that in the back of the room, and we also post everything on social media. And I would like to thank the Humanities Institute staff for all they do to make everything about this series possible. Another of the goals of the Institute is to link public programming to the curriculum through a selective seminar that facilitates in-depth conversations between speakers and students. And as is tradition, a student from that seminar will introduce tonight's speaker. Elizabeth Leung is a sophomore English major from Albuquerque, New Mexico. She's a new student program peer mentor and a student coordinator for the Scripps College Academy, and she is also one of the few people who claim Moby Dick as their favorite book.
Hi everyone. Lisa Hajjar is a professor of sociology at UC Santa Barbara. Her areas of expertise include sociology of law, law and society, international and global studies, and political sociology. Her research interests include human rights, international law, torture, war, and conflict. She is the author of Courting Conflict, the Israeli Military Court System in the West Bank and Gaza, and Torture, a Sociology of Violence and Human Rights. She is currently working on a book about anti-torture lawyering in the United States in the post-9/11 period. And she was the Edward W. Said Chair of American Studies at the American University of Beirut from 2014 to 2015. So please join me in welcoming Lisa Hajjar.
Well, it's a pleasure to be here, and thank you very much for coming. Thank you to Laura and Adrian and everyone who made my visit possible. I know this, as Laura alluded to, it's been an interesting week, and I was very honored to have the chance to speak to Laura's students in class. So the title of my talk was Owning Up to American Torture, sort of a statement. I was thinking that this is something, preaching the gospel of anti-torture. But when Donald Trump, issued his some statement today about his top 5 priorities and waterboarding being one of them, I was like, I thrive on this kind of stuff. So while you all may not be well prepared for the coming period, I live for this shit. Anyway, so as we start now, so we're now into the 16th year of an evolving, expanding war on terror, and the end is nowhere in sight. So of the many consequences that have resulted from this war, the ones I'm going to be focusing on today relate to governmental authorization for torture and its implications for the country as we prepare to install a new president who has listed a return to torture among his priorities. So in response to the terrorist attacks of September 11th, top officials in the Bush administration took decisions to authorize torture as a tactic for fighting terror and keeping Americans safe. For several years, the torture program operated largely secretly, but it affected thousands of people captured, rounded up, or sold to US forces for bounty. When information about the torture program started to leak out and become public, some Americans were appalled, while others, including the intellectual authors of the program, defended it as necessary and effective. In January of 2009, on his second day in office, President Obama signed an executive order canceling the torture program. But his administration blockaded accountability for the officials and state agents responsible for these gross violations of international law. President Obama, who started his first term with the optimism that he could bring the country together, justified his opposition to accountability as a means of avoiding a partisan battle, and he stressed that it was time for the country to look forward, not backward. Both the Bush and the Obama administrations shielded information about U.S. torture behind a cloak of classification and denied any justice to victims by invoking state secrets to shut down lawsuits. But the Obama administration distinguished itself by adopting an unprecedentedly punitive approach to whistleblowers who release classified information about torture and other illegal government policies. Now, the consequences of these actions by the executive branch over the past two administrations have served to foster public ignorance about the actual failures of the torture program, and what's worse, to fortify public indifference about what American torture has done, not only to its victims, but to the world, to the architecture of international law and rights, of which the right not to be tortured is the first among equals, comparable only to the right not to be enslaved. The confluence of official secrecy, unaccountability, rhetorics of denial, and bald-faced fabrications that torture is effective have contributed to the coarsening of public attitudes about the principles of human dignity and rights. So for evidence of these claims of ignorance and indifference, one need only look at the 2016 U.S. presidential race. Republican Party candidate Donald Trump, who is now the president-elect of the United States, pledged to bring back the Waterboard and a whole lot worse. Like most of the other Republican contenders who vied for the 2016 nomination, and 11 of the 12 who ran in the 2012 race, Trump ran on promises to resurrect the torture techniques authorized for use after 9/11. His and other pro-torture candidates' premise was that these techniques work, that the kinds of people subjected to waterboarding and other forms of brutality during interrogation and detention deserved it, and that their cancellation in 2009 was a mistake. While the Democratic Party nominee Hillary Clinton made no such promises to restore torture, she gave no indication that had she been elected, she would pursue accountability or declassify information that is necessary to reshape public discourse in order to reverse a trend in which today a majority of Americans would accept or endorse the use of torture under certain circumstances because they've been led to believe that it works, or that those foreign Muslims subjected to torture deserved it. So indeed, popular support for torture has become a litmus test for a particular brand of hard-eyed patriotism on the American political landscape. And that brand has prevailed in the election victory of Donald Trump and the reinforcement of Republican control in both houses of Congress. As the reality of a Trump administration starts to set in, we should ponder whether the new reality will include a return to torture. Now, many in governments engage in torture, but what makes American torture distinctively consequential relates to the role that the United States plays in the world. Indeed, many human rights violating governments have pointed to the U.S. example to justify their own egregious practices and brushed off U.S. criticism of those practices as blatant hypocrisy. I would offer a few points about why it is necessary and high time for Americans to start owning up to torture. First, this is now part of American history. Like slavery and Jim Crow segregation, like genocide against Native peoples on this continent. Yet unlike those other shameful chapters in history that are by now well known and documented, most Americans know little or nothing about our own history of torture because so many aspects of it are still secret, and because what is known has been denied or reinterpreted into something necessary and good. Like secret laws or secret prisons, secret history is anathema to democracy. Second, torture is a crime, and it's not just any crime. It's a gross crime under international law. The purpose of the prohibition against torture, like the prohibition against genocide, is to limit what states can do to people when they are at their most vulnerable. Without those limits, and without respect for the or enforceability of those laws, human beings have no protections from the worst forms of state violence. So the first step in owning up to torture is to learn about this history, and this involves understanding why and how the government would institute a torture program. Of course, the 9/11 attack was a pivotal event. This was the single most devastating and deadly assault by a non-state group, and for the United States, it was the first attack on the homeland since Pearl Harbor. The fact that an attack of this magnitude could occur and the fear that more were planned were seized upon as evidence of the intelligence failure, illuminating how little was known about the shadowy world and workings of Al-Qaeda. Thus, the waging of a war on terror would be, in its first phase, a militarized campaign for actionable intelligence. But decisions to authorize torture for these purposes were not inevitable, nor were these decisions woven out of thin air. Rather, they relate to a larger global history of modern wars and international affairs. Like all asymmetric wars that states wage against non-state groups, human intelligence is a, if not the, premium strategic objective. What this means is that information must be extracted from human beings to obtain knowledge about the structure, membership, and plans of unconventional enemies. Asymmetric wars differ from conventional wars in many ways, including the fact that without intelligence, state forces are unable to distinguish enemies from people who are not enemies, because those whom they're fighting don't wear uniforms or distinguishing insignia or carry arms openly or fight with big weapons. The main means of acquiring human intelligence include signal monitoring by tapping into phones and computers, surveillance by spy cams, satellites, and aerial drones, the use of spies and recruited informants, and interrogation. In many asymmetric wars over the last century and a half, including those waged by colonial states against anti-colonial movements and by authoritarian regimes of various ideological stripes against resistance or pro-democracy movements, torture is a common practice in interrogation, and the examples abound. In the French war to retain control of Algeria, torture was used to crack the identities and locations of the leaders of the National Liberation Movement, whose tactics included bombings in public places. The torture techniques used by the French, combining water and electricity, had first been pioneered in French colonial Indochina and then transported to Algeria. So Gilles Pontecorvo's film, The Battle of Algiers, depicts how the French used torture to make people talk, as well as a speech by a French colonel, rationalizing its use as necessary to defeat the enemy. The Battle of Algiers was screened for Pentagon employees at the start of the War on Terror. In the Vietnam War, the CIA's Phoenix program to root out the Viet Cong combined brutal torture with extrajudicial executions. And the torture-murder model featured in some of the dirty wars waged by Latin American military regimes in the US-supported global war against communism. But let us consider for a moment the question, did torture work? The French lost Algeria, the United States lost Vietnam, and the military juntas of Latin America lost power. Hence, if torture was a strategic method to win these wars, then no, torture didn't work. That lesson was lost on Bush administration officials. Before the hot war in Afghanistan had even started, and before any suspected perpetrators of 9/11 had been captured, decisions were taken to initiate a policy of violent interrogations in the pursuit of actionable intelligence. On a Sunday morning news program a week after the 9/11 attack, the torture policy's chief architect, Vice President Dick Cheney, blithely described the approach the government intended to pursue, with a quip about the need to, quote, take the gloves off. When U.S. military units were tasked to interrogate and detain people, first in Afghanistan, then in Guantanamo, and later in Iraq, thousands of prisoners were subjected to systematic torture and routinized cruel, degrading, and inhumane treatment while being held in protracted incommunicado detention. The CIA rendition and detention and interrogation program, which was authorized a week after 9/11 and was separate from the military's, included all those practices as well as kidnapping, extraordinary rendition, and forced disappearance into secret prisons referred to as black sites. All of these practices are illegal. They violate federal as well as international human rights and humanitarian law. So we should ask ourselves, how did officials of a government ostensibly committed to the rule of law rationalize policies that so brazenly defy the law? One set of factors relates to the nature of the state itself. Unlike authoritarian regimes that engage in torture with no regard for the law, because that is the essence of authoritarianism, a political democracy in which the government is accountable to the people does not have the luxury of disregarding the law. And indeed, U.S. officials who engineered the torture program did not disregard the law, they reinterpreted it. These reinterpretations included the crafting of a heretofore non-existent category, unlawful enemy combatants, who were classified as neither combatants nor civilians, and thus who could be deprived of all the rights that would attach to those other categories, including the rights not to be tortured, kidnapped, disappeared, or held indefinitely without charge or trial. Oh, sorry. Oops. Wait, sorry. Oops, sorry. Okay. Another reinterpretive move involved narrowing the legal definition of torture to exclude anything less severe than the pain arising to the level of organ failure or even death. And that's a direct quote from a Justice Department memo. In this way, it could be claimed, the extreme, intense, and protracted violence and dehumanizing degradation applied to prisoners over months or even years could be deemed not torture. The government lawyers who formulated these interpretations did take into consideration the prospect that a future administration might not accept their interpretations. Therefore, they layered in a radical interpretation of the Constitution to argue that the Article II powers of the President as Commander-in-Chief in wartime would include the right to authorize anything he deemed necessary for the security of the nation, even if it violated the law. And this interpretation would provide a golden shield from prosecution for those state agents and government-funded contractors acting under the authority of the President. Now, I'd like to stress two things about this first phase of legalizing torture, which unfolded between 2001 and about 2003. First, there were people in the State Department, the FBI, and the military who resisted these radical reinterpretations of the law and rebutted the underlying contention that violent interrogations were necessary and effective to elicit accurate information. But their critiques were ignored, and they, for the most part, were sidelined. Second, the process involved in legalizing torture was done in secret, and the rationales underlying it were classified at the time. Secret laws, or in this case, secret reinterpretations of the law, are inimical to democratic governance. Another set of factors relevant to the question of why the Bush administration would officially authorize a program of torture, kidnapping, and forced disappearance relates to the political history and practice of U.S. realpolitik in international affairs, and the ideological history of right-wing animus towards international law. In the aftermath of World War II, there were massive transformations in international law, including the establishment of universal human rights and the expansion of the laws of war, or the international humanitarian law, the latter through the promulgation of the Geneva Conventions of 1949. The underlying objectives of these post-World War II transformations was to prevent in the future the horrors of the immediate past by imposing new legal limits on the rights of states. Consequently, states could no longer claim the right to exterminate or torture people, but they retained their status as sovereign entities in a durably state-centric world. As the post-World War II architecture of international law was being constructed, effective enforcement mechanisms were deliberately left out. So respect for the law depended mainly on states' own behavior and self-enforcement. While some states willingly instituted domestic reforms in keeping with their international legal obligations, most states refused to regard the rules and restrictions of international law as binding and enforceable, especially if these contradicted vested interests. This unenforceability was compounded by Cold War rivalries and superpower competitions for power and influence across the global South. In the United States itself, the antipathy towards international law was strong. Racists and segregationists who wanted to maintain white supremacy opposed the principle of universal human equality. And the power brokers of foreign policy and national security opposed the idea that international affairs, or indeed anything occurring beyond the domestic jurisdiction of the state, should be restricted by law rather than being driven by interests. The influences of right-wing racism and bipartisan realpolitik can help us understand why the U.S. fought a lawless war in Vietnam and supported some of the worst human rights violating regimes in Latin America, the Middle East, Southeast Asia, and Africa, including apartheid South Africa. Now, the heyday of lawless realpolitik seemed to wane with the end of the Cold War. During the 1990s, new international law enforcement mechanisms were established and new opportunities emerged to put violators on trial. Realpolitikers were especially agitated by the retooling of the 19th century of the doctrine of universal jurisdiction, which led to the 1999 Pinochet precedent, in which a former head of state, Chilean dictator Augusto Pinochet, was deemed to be prosecutable in a foreign court for the crime of torture, although he evaded that fate as a result of British political decision-making. Human rights activists and international lawyers began clamoring for the opportunity to put other violators, including Henry Kissinger, on trial for their roles in gross crimes perpetrated in the previous years and decades. Now, this abbreviated history is relevant to understand why Bush administration officials disregarded the nation's international law obligations. It was not just that Cheney and other realpolitiking neoconservatives holding the reins of power merely disliked the constraints that international law would impose on the exercise of U.S. prerogatives globally. Rather, these radical right-wingers used 9/11 and the war on terror as an opportunity to eviscerate the restrictions on states' rights imposed after World War II and the post-Cold War gains in enforceability and respect for the law. By 2006, the torture program had been largely derailed. In my opinion, three of the most important factors were exposés by diligent investigative journalists and human rights organizations that brought some secret facts to light. And this includes, most significantly, the Abu Ghraib photos, which provoked an international scandal when they were published in April 2004. Another factor was litigation in U.S. and foreign courts that, although almost never winning judicial victories, raised the costs of torture politically and diplomatically. And another factor was details about crimes of state revealed by whistleblowers such as Chelsea Manning and John Kiriakou, as well as first-person accounts by people who were tortured and then released. Now, I use the term derailed deliberately. During the latter years of the Bush administration, the CIA black sites were emptied, but torture was not decisively re-prohibited, let alone re-outlawed. In January 2009, President Obama ended the torture program, but this stands on very shaky grounds of an executive order that can be canceled or reversed by the next president. The Republican Party, which has fashioned itself into the pro-torture party, controlled both houses of Congress throughout most of Obama's 2 terms, thus concretizing the re-prohibition in strong legislation was impossible, one of many consequences of a deep partisan divide in Washington and across the nation. Optimists today might point out that, in 2015, Congress did pass a law affirming that all U.S. interrogations must be done in line with the Uniform Code of Military Justice, which is the rules governing the military and also extending to any other agency doing interrogations. Currently, the U.S. The Uniform Code of Military Justice prohibits torture. But the obligation imposed by the 2015 law is to abide by the code, which can be altered in the future by a pro-torture majority in Congress. Now, although Cheney and most of the other architects of the torture program are out of power, and the authorization for torture has ended for now, given the posture of the next president, who has prioritized bringing back the Waterboard, we very well may see a return to torture. But even in the precarious here and now, the afterlife of torture is haunting national politics. It is evident in the continuing detention of dozens of prisoners at Guantanamo who will never be, because they can never be tried, because there is no court-worthy evidence against them, and the insurmountable hurdles of closing that prison, which Trump has vowed to keep open and expand. The most haunting ghost of torture is the fact that the individuals who've been charged with perpetrating the 9/11 attack, including the alleged mastermind Khalid Sheikh Mohammed, are years away from a trial because of their treatment in CIA black sites. The post-9/11 evisceration of international law norms and rules remains very much intact in other ways as well. Drone warfare and extrajudicial executions, which have succeeded interrogation and detention to become the Obama administration's signature strategic approach to waging the ongoing war, rely on the same contra-legal rationales that the United States can pursue its national security interests globally in a manner unconstrained by the law. So how has this history affected and damaged the architecture of international law that was built to protect human rights? In my opinion, 2 of the most important factors are the power and influence of the United States and the efforts that were expended by government officials to legalize the illegal. The results were a new paradigm for war that departs from the rules laid out after World War II. What is new about this counterterrorism war paradigm is not that the wars are being fought in unprecedentedly new ways, although armed drones are a 21st century invention, but rather that the realpolitik disregard for restraints on state power and asymmetric wars has been legalized. In the counterterrorism war paradigm of with us or against us, the latter and all that is proximate to it are deemed rightless, torturable, targetable, or otherwise expendable in the pursuit of our national security. This paradigm upends the principle of humanitarianism and the important distinction between combatants and civilians. Painting terrorism with a broad and non-discriminating brush is used to justify extreme and indiscriminate forms of violence. And indeed, because of the power and influence of the United States, we see this paradigm being invoked by many regimes in their own so-called counterterrorism wars in Syria, Yemen, and Gaza, to name just a few. In the US war on terror, the will to torture was the original sin, and it spawned the will to drone strike and extrajudicially execute. The consequences of this trajectory have been momentous and global. So let me close with a few thoughts about what needs to happen for Americans to own up to torture. The most pressing imperative is the need to construct a new narrative about this history and its consequences, one that integrates lessons from the mistakes and deeply flawed policies that have been made under the cover of national security. Specifically, constructing this new narrative would require more declassification, more litigation, and more civic education. The importance of declassifying information about the torture program cannot be underestimated. This program was illegal, ineffective, and counterproductive to the very goals of national security for which it was instituted. U.S. torture served as one of the major recruitment tools for old and new organizations against which the United States remains at war, including the Islamic State. The torture program has damaged relations with allies and degraded respect for international law norms and rules. On top of that, it was an utter failure in producing actionable intelligence. In 2012, the Senate Select Committee on Intelligence completed a 6,000-plus page report on the CIA's rendition, detention, and interrogation program. This Senate report purportedly contains abundant evidence and analysis of its failures and strategic costs. But this report remains classified, except for the heavily redacted 500-page executive summary, which was released in December 2014. So in order to know the past, as a first step to understanding and learning from it, this report should be declassified and made public. As long as it remains secret, falsehoods and fabrications about the efficacy of torture can continue to be bought and sold in the public square. And this is something people can do now, is bring pressure on the Obama administration while it still holds power to release this report, because it is the most authoritative account of the history of post-9/11 torture. The reason litigation is important is because the Bush administration and then the Obama administration legalized their illegal policies. And that bell cannot be unrung. While the damage could be repaired through new legislation, given the dysfunctionality of Congress, as well as public attitudes supporting torture, this prospect is inconceivable, at least for now. Therefore, litigation is the only option available at this point. So courts and lawsuits are the main vehicles, not only for rolling back the law-defying interpretations adopted by the executive branch, and also for holding the line in which torture has been re-prohibited, but also for accountability. Real and robust accountability, that is, putting torturers and their abettors on trial and in jail, is a means of deterring in the future a repeat of crimes of the past. In this regard, the pursuit of accountability for crimes of state in Latin America is a model that could be emulated by the United States. Of course, it took Latin Americans more than a decade to begin pursuing their own torturers, time that was needed to see a sea change in public attitudes and balances of power. In recent months, there have been several positive developments in the realm of litigation. The two psychologist contractors who were hired and paid $81 million to design and run the CIA torture program, James Mitchell and Bruce Jessen, are being sued in Washington state by several victims. The court is not only allowing this court case to proceed, which in itself is a novel break from the state secret shutdowns, but also has ruled that several top officials from the CIA can be called as witnesses to testify about what Mitchell and Jessen did. And in October, the Fourth Circuit Court of Appeals reinstated a previously dismissed lawsuit by victims of torture at Abu Ghraib against the private contractor firm CACI Premier Technology. In a concurring ruling, one judge emphasized, and I quote, "It is beyond the power of even the president to declare torture lawful. The determination of specific violations of law is constitutionally committed to the courts, even if that law touches on military affairs." And finally, I would emphasize the importance of civic education. There's a need for citizens to learn and teach the lessons of history. Civic education begins with a battle for narratives in order to inform people and contribute to a greater public understanding about what is wrong with torture. Civic education also includes empowering people to aggressively assail the vocal pro-torture constituency. And this is where students and scholars can play an important role. It's incumbent upon those of us who care about these issues to produce empirically sound and analytically persuasive arguments against torture and against those who support torture, because this is a way of demonstrating respect for democracy and the rule of law in this country and human rights and humanitarian principles on a global scale. So given the outcome of the 2016 election and the victory of an ardently pro-torture candidate, civic education about torture and organizing against it may well become the 21st century version of the abolition movement. Slavery and torture have in common the degradation and destruction of some human beings for the instrumentalized benefit of others. And that's not the kind of world I want to live in. Happy to take questions on any topic. Thank you. Don't be shy. Here in front. Oh.
Thanks so much, Lisa. I'm not sure this is true, and maybe you know, but I had heard that Trump has requested registration of all Muslims in the United States. It sounds like what Hitler did to me. And I don't know, is that true? Or is this just
well, he hasn't, to my knowledge, I mean, he never was particularly clear. He spoke in generalities during the campaign. He emphasized extreme vetting. I don't think he's clarified what extreme vetting means. He certainly has referred to his desire to see the institution of so-called extreme vetting for people coming to the country under any, sort of traveling into the country. And he's identified, he said once he realized that he couldn't just give a blanket, imposition to block all Muslims, he then said, well, he could, and in fact, the executive branch would technically have the authority, and it builds on this kind of history I was just talking about, to, sort of designate people from certain countries on the basis of the situation in those countries. So it's a way of still, sort of either scapegoating or profiling Muslims, but the cause being shifted from their Muslimness to their Syrianness or their, Iraqiness or something to that extent. So, yeah.
It's not legal, is it?
Well,
To register.
Oh, not in the United States, I don't think so, no. Although, yes, no, that would be.
Thanks for that. That's really great. I have a question about the court case you mentioned in Washington. I'm just wondering what sorts of outcomes would be possible, whether it would sort of go to a higher court, or what's the sort of imagined outcome of this case, aside from, I believe, the way that it's framed as restitution for the victims?
Yeah, well, it's damages, right? So, I mean, in the United States, just in case people don't know this, the only kinds of, in our legal system in this country, only the state can bring criminal cases. So in cases that are not brought by the state, I mean, people can sue other people for, harms and so on. So this particular case, was thrown out. I mean, almost all the court cases that have, been brought involving victims specifically have been, basically thrown out across the years. First, during the Bush period, the Obama period, on the grounds that the issues involved would, to even allow the case to proceed would essentially, reveal state secrets. But and this case itself was thrown out on those grounds, and I think that there was a new move to just sort of appeal it to the Fourth Circuit, and it's actually quite surprising that the Fourth Circuit would be willing to actually reconsider this position, since the Fourth Circuit is traditionally quite a conservative court, very sort of backing up government positions. So, in both of the cases I mentioned, Mitchell and Jessen on the one hand, and I guess you say Cocky, or I'm not sure exactly how you pronounce the acronym, are government contractors. So if we think about this strategically, on the one hand, and especially in the case of Mitchell and Jessen, there's too much information has come out about what the CIA did and the illegality of it. So the possibility of damages seems legitimate. But because it was the government that hired private contractors, although it's the private contractors being sued, part of the point about litigation is not just the immediate question of justice, but how history and facts can be known through litigation, through the processes of, making, materials and witnesses, et cetera, available. And so for that reason, really one of the only ways that torture has been seriously fought since it became, since 2002, is by lawyers in court. There are no significant anti-torture social movements in this country. So it very much has been about litigation. Really much of what we know, any of the gains and the critiques have come from really investigative journalists, whistleblowers, and, anti-torture lawyers. So I think, it's very possible that, who knows then what a jury might find, though, because this will be obviously a very complicated case for, average people to understand, the legal questions. So. I saw somebody else over there, too. You want to?
At the risk of blending this out, you and I were talking before
yes.
about Israel, and there's a long controversy about the use of torture by the Israeli government against Palestinians, including children as young as 6 years old. Would you like to comment on that?
Yes, that's how I started my academic career. One of the ways in which we think about, and I'm going to give you a big answer to a targeted question. I made reference to the fact that, authoritarian regimes can torture without any concern for the law. But governments that regard themselves as like political democracies, and Israel is one such government that regards itself as a political democracy, are, sort of engaged in this kind of reinterpretation. And in fact, Israel was the first. Israel was the first state in the world to legalize torture, which they did in 1987, and they justified that legalization. They euphemized what was being done as not torture, but, quote, moderate physical pressure, and then they rationalized it as necessary and legitimate in order to combat hostile terrorist activity. So while Israel had been engaging in torture systematically since 1970, the authorization for torture came as an outcome of a domestic Israeli investigation into the possible wrongdoing of the Shin Bet, or the General Security Service. And what the Landau Commission, this commission that was investigating the Shin Bet, discovered was, in fact, yes, just as people, Palestinian prisoners and their lawyers had been accusing, Israel had been engaging in torture systematically since 1970. But then Israel sort of legalized it, and it took from 1987, when torture was legalized, to 1999, when finally the Israeli High Court of Justice issued a ruling consolidating several cases that said systematic abuses were unacceptable, but they left open that so-called hypothetical ticking time bomb window. So in a sense, I think what's going on in Israel now is slightly different than what was happening before. Really, from the beginning of the occupation in 1967 through the mid 90s, like into the Oslo period, the way in which Israel maintained its control over the West Bank and Gaza, it ruled the Palestinians through a military administration, was in part hoping to maintain a complete quiescence of Palestinian activities. The Israeli government regarded any manifestations, even of nationalist expression, to be a national security threat, and it was criminalized. And so one of the ways to kind of deter any kind of political, or attempt to deter any kind of political movement, was through the processes of arrest, interrogation, the use of torture, the elicitation of confessions, conviction on the basis of those confessions, and then imprisonment. And so this was the model that Israel used to maintain control for decades. It begins to shift then with the Israeli military redeployments out of population centers, and particularly with the start of the Second Intifada in September of 2000, where Israel continues to arrest and interrogate Palestinians, including, there's really almost no limit for the age. Palestinians as young as 9 and 10, possibly even younger, have been arrested, and technically people under the age of 12 can't be interrogated. But Israel has shifted its strategic policies prior to, but in the same pattern that the United States follows afterwards, towards a more killing policy rather than an imprisoning policy. And as Israel was the first state in the world to legalize torture, Israel also was the first state in the world to proclaim the legality of targeted killing, which they did in November of 2000. And if you look at the U.S. torture memos, and you look at the memos that have come out about the Justice Department's legal authorization for our targeted killing program, they are extremely close in argument. They're following the patterns of rationales that were developed by Israeli lawyers earlier.
Hello, thank you for your talk. You talked about how torture is ineffective. Is there concrete evidence that proponents of using torture point to show that, how do they justify their torture?
Wait, in other words, I don't understand.
So you talk about how torture is ineffective.
Yeah.
So how do proponents of torture justify their torture? Is there any concrete evidence or any documentation?
Oh, sure. Well, the question, and this is something, pardon me to the students in Laura's Deeb's class, because I sort of touched upon this, and another student had asked that, and it's a good question. And I'm going to give you a complicated answer, although very sociological. If you want to understand why torture happens, you can't really understand it by looking into just the torture chamber or looking at victims. You need to look at the perpetrators. So you need to say, who has the power to torture? What interests are being served by torture? What use is torture serving? So, for example, there's we could break out torture into 4 different kinds. Judicial torture means torturing people, a sort of pre-trial, in order to elicit confessions in order to prosecute them. So for governments that don't care whether or not the confession is true, but their interest is in putting people in prison, then it doesn't really, and especially in contexts where, there's not a lot of oversight or respect for the law within the interrogation services, or they operate secretly, it doesn't matter if the confession is true, if the goal is to get a confession in order to put people in jail. And just to bring it a little bit home, some of you probably are aware of the fact that, it was revealed relatively recently that the Chicago police have been running what is essentially a black site in the city of Chicago for decades, since the 1970s, bringing people in who are arrested, mostly black and Latino people in Chicago, bringing them in off the books to the secret site, beating the hell out of them, using electricity and other forms of brutality in order to get them to confess, and then bringing them to the police stations and charging them and having their confessions, and people were imprisoned. The city of Chicago is now facing lawsuits from dozens, if not hundreds, of people who were tortured into false confessions and imprisoned for years as a result of this. Because that the police were mainly just interested in putting people in prison. We were in a war on crime, a war on drugs. And if you'd even think about other ways in which people would torture would be instrumental for some purposes, think about the show trials during the Stalin era in the Soviet Union, where it didn't they wanted people to they brutalized people in order to get them to confess to being enemies of the state, so they could be then paraded out and made an example of for the public. Another form of torture is penal torture. Penal torture would refer to like the really brutalizing punishments, but not ones that are authorized through a court of law. So it'd be like sort of, when people are physically or psychologically harmed for punishment, but that punishment is done sort of extrajudicially. It's like extrajudicial punishment. Then there is what is particularly common in the War on Terror, for example, is interrogational torture, where people are interrogated for the purpose of actionable intelligence. And indeed, in the War on Terror, one of the biggest and most fascinating sort of institutional conflicts within the US government was the fact that the CIA, which has no experience of effective interrogations, and in fact had even been out of the human intelligence business by and large during the post-Cold War decade, but they're the CIA. The FBI, on the other hand, is at least those who are dealing with these kinds of issues, their use of interrogation is always done with the goal of prosecution and conviction. And therefore, FBI agents early on in the War on Terror were even reading people who were captured in Yemen or wherever, they were reading them their Miranda rights. And they were doing professional interrogations, which involves building rapport, et cetera, et cetera. So when the first so-called high-value detainee, whose nom de guerre is Abu Zubaydah, was captured in Pakistan in March of 2002. He was immediately, he was held for a few days, I think, and then sent off to Thailand to a black site. But it was professional FBI interrogators who started speaking with him, and he started giving information. And that information coming out of the black site in Thailand was being sent back to Washington. And people in the White House and all the people in the sort of inner circle were so excited that this guy under interrogation. They first of all, they assumed that this guy Abu Zubaydah. They kept claiming, we've caught Al Qaeda's number 3. This guy wasn't even a member of Al Qaeda, but they didn't even know who he was. And so they were touting this whole idea that he had all this incredible information. He was basically a mentally ill secretary who moved people in and out of sort of camps in Afghanistan. So he certainly knew people in Al Qaeda, but he wasn't by any stretch of the imagination a thing. But anyway, so he's being interrogated by FBI agents. Intelligence is coming out. George Tenet, director of the CIA, gets very excited, and then he's informed, this is done by the FBI. And it was the decades-long institutional rivalry between the CIA and the FBI. So the CIA basically sends in Mitchell and Jessen to come in, and they immediately strip Abu Zubaydah naked and start doing various things to him. They don't know anything about Islamist politics. They don't know anything. They'd never done interrogation. They had no knowledge about the Middle East whatsoever. Their skill set was twofold, Mitchell and Jessen. They basically were psychologists who work with the Army in training U.S. soldiers in the kind of techniques that they were subjected to as a training matter if they were to be captured by a government that engages in torture. So Mitchell and Jessen had the brilliant idea they could reverse engineer these techniques. So Mitchell and Jessen go in, they start talking to Abu Zubaydah, and he stops talking, and then they send in the 2 FBI dudes, and those guys, he starts talking again. Tenet gets very excited. They realize FBI guys again, send in Mitchell and Jessen. One of the FBI agents, Ali Soufan, who wrote a very interesting book about this called Black Banners, threatened to arrest Mitchell and Jessen on the spot. And the FBI just didn't want that kind of a sort of pissing contest with the CIA, so they pulled their guys out. And that, in a sense, that's how the interrogational actionable intelligence thing. And then the very last form of torture is, the kind that was we might be familiar with that in terms of Latin America during the Dirty Wars, terroristic torture, where some people are tortured, and whatever happens to them, that may be absolutely terrifying, but it's the idea that the rest of society is being terrorized by the knowledge that, people come in the night, knock on the door, take people away, and they're never seen again, or they're seen years later having been brutally tortured, or their bodies are thrown on the sides of the street. So there, the torture of certain people is used to terrorize the rest of society. So these are sort of the functionalities of the different points of torture. But as the Senate, even the heavily redacted Senate report on the CIA's program would attest that there literally was nothing that was gained through the CIA's torture. And then the Senate also sort of alludes, although it's classified, to all the things that have been damaged by the CIA torture program.
Hi, thank you. That was awesome. So I'm kind of curious as to why you mentioned like humanization of the victims of torture. So if you could just speak a little bit to that.
Sure. I think, of course, in a sense, when, war by definition, involves processes through which, people get, sort of regard their enemies as dehumanized, and certainly that would be true of those actually fighting in wars. But it was, I would say, that the kind of trigger of 9/11, which was not like the United States was some cornucopia of freedom and equality for Muslims prior to 9/11, but it was the kind of extreme nature of the attack itself. And the fact that the government then declared a war on terror, and the perpetrators of 9/11 were all, Muslim men. And so it opens up this kind of a phenomenon. But the going into war in Iraq, and then sort of the spreading of both the boots on the ground wars, as well as, sort of the kind of aerialization of our strategic approach with drone warfare, are ones in which it's like, the enemy and this is really what I think is the element, the essence of the counterterrorism war paradigm, which it does not abide by. It's built on dehumanization. It's built on a kind of a muscular parochialism of national security, that kind of notion that sort of the lines can be drawn, and everybody on the outside, even if there are innocent people on the other side, we don't have the time or the luxury to sort them out because, our protection is the most. So if you even just think about the kind of statements that Donald Trump made during the campaign, just to illuminate, he's tapping, he wasn't making things up that are not already widely circulated. So when he was justifying waterboarding, from 2015, since he announced his candidacy, his whole language was, well, they do worse things to us. Why shouldn't we waterboard them? They do worse things to us. Who are they? And that is actually a very common argument. If you talk to people who are not torture experts, and anybody who likes torture is definitely, by definition, not an expert. But if you talk to anybody who, sort of just ask your average Trump-supporting voter what they think about the waterboarding and whether they think that it would be good for America to, sort of go back to something that we've so, tenuously moved away from, I would bet money that people would say, well, they do bad things to us. Because a lot of times the public take their clues from elite figures who speak in these ways, and these are the kinds of terms that have been, from Cheney talking about we're going to take the gloves off. Cheney himself, just to not put everything on, to give you a little bit of history, one of his sort of frames of thinking was called the 1% doctrine. And we can see this, even in the Iraq War, which has been an unmitigated debacle, but was if there's 1% chance that something is true, let's act as though it's true and act upon it. So this, and he's the architect of the torture program. He was the head cheerleader of the Iraq War, et cetera. And so that is an innately, hyper-sovereign, muscular, parochialist, and dehumanizing war posturing position that lends itself to all these kinds of policies and to the kind of public support. And I want to say public support. The public support is expectable, when this happens. It has incapacitated the public to understand what's wrong with these things. I mean, and not even what's wrong with these things like, oh, let's be, you know, kumbaya liberals, but like what's wrong with these things you know, in a world in which people care about them. I mean, in other words, it's a very devastating period, you know, and this does not begin yesterday or Tuesday, it goes back, but it's a very devastating period in terms of public attitudes about humanity, about universal humanity. Wait, I think you need a mic.
Something about the relationship between torture as a technique of warfare and then what happens when it becomes a topic of political discourse in which Trump or others brag in some ways about supporting it. Are those different elements or how are they connected? Because it seems that it seems to me that there's more than one thing going on.
Mm-hmm.
There, and partly it has to do with the publicity about torture and the legal cases and the need to publicly justify it. But I guess is it useful or all important to talk about the transition between its longer use as a technique of warfare and then its political use as a source to mobilize public opinion about those wars?
Well, it's interesting. I mean, like no government in the world, well, maybe now, you know, maybe now the United States will be leading this, but let's say up until the war until the turn of the 21st century, torture was rampant. I mean, a majority of governments engaged in torture. No one acknowledged it. Either they denied it through basically saying we don't torture, or they euphemized it. You know, like, oh, you know, what we're doing is moderate physical pressure, it's not torture, or whatever. So nobody, like, sort of owned torture. And it's really, you know, the prohibition of torture in the late 18th century is one of the things, when that happens, and when torture goes from being a necessary, essential element of the way in which law enforcement could operate on continental Europe to extremely rapidly being abolished. Like the law of torture was abolished in the period of 30 years. Governments at first, you know, centuries, you know, and referencing back to the Romans, which reference back to the Greeks, you know, did away with torture. It was literally one of the most clear historical events that illuminate what is oftentimes a much more blurry thing when we talk about the Enlightenment or the idea of the rise of the rights of man, the idea that, you know, people have certain kinds of integrity. And so it's only really in the 20th century with sort of the, you know, sort of as the colonial states are, you know, waning and the rise of national security states, and as more states become politically independent and have their own, however they determine national security to be. So torture, you know, has a massively resurgent comeback in the 20th century, but it's hidden. Like unlike in the, you know, 18th, 17th, 16th centuries, it's hidden. And so there's a lot of denial going on. It's really only, I mean, I would say that really the legalization of torture and the power of the United States have been the first instances that I could think of that significantly seek to legitimize torture openly, and where people are literally embracing torture as a feature of their American identity. I mean, many countries engage in torture, but I think that this is a very unique one because of the fact that the way in which Americans identify with the government. I mean, it's the paradigm, it's the liberal ideology of torture. People see the government as their government. So if the government is torturing, then they are going to be supporting of what the government does. I mean, it's part of, I mean, it functions in this kind of patriotic mode. And so that it creates a big challenge to trying to separate people, you know, torture from people's understandings of themselves, you know. I mean, and it's a big project, I think, for the coming years.
I've been wondering, sitting here listening to this, is there any legal protection outside of military, which I'm very familiar with, for a person who defies the order of the president to conduct something like this?
We're going to be finding out now because the CIA has already said that we're, President Trump to order the CIA to get back into the business of torture, they would refuse. There is, you're talking about outside, in the military or outside the military?
Outside, because I've been in the military, I know better.
Yeah. Well, I mean, the military itself, I mean, it really got so blurred out because of, the phenomenon of the take the gloves off and the Geneva Conventions don't apply. But outside of the military, I mean, no one else torture is really a crime of state. I mean, it's not only state agents that can commit it, but torture is when an individual is taken into custody and harmed for a purpose that is public or political rather than personal. So, I mean, even if, kidnappers or things do things that look like torture, or domestic violence look like torture, it's not torture under the law of torture. But so the police in this country are, in theory, governed by, you're not allowed to do you're not allowed to harm people on purpose. You're not supposed to. You're supposed to take them into custody and then do things. So I think that the law is on our side in that regard. The question is whether the law gets enforced and respected. So, yes?
Thank you very much for coming. I think that was eye-opening for all of us. My question is, what qualifications, if any, were used to capture and later torture people? Was it anyone that we labeled a potential terrorist? Was it someone that we thought had information? Or just someone like walking on the street?
Okay, so the way in which it worked was, the hot war started in Afghanistan. The war itself started October of 2001. Boots on the ground started in November of 2001. Essentially, the United States and the allies that were involved in the war in Afghanistan, they didn't know who they were looking for. They knew they were looking for Osama bin Laden, but they had no idea, they didn't know anything about the structure of Al-Qaeda. They didn't know these things. So they started rounding up people, just going in, sweeping. It was basically sort of profiling, the idea that you're just going to get a lot of people and bringing them in. The first prison interrogation center in Afghanistan was Kandahar, and that was operating from late November of 2001 to the spring of 2002 when Bagram comes into play, a much bigger facility. So, several things to know about. It literally was whoever was being rounded up, is one thing. The US government was dropping leaflets all over Afghanistan saying, if you know any any terrorists, we'll give you $5,000 if you turn them in. So, people are like, I hate my neighbor. His cow is shitting on my yard. They turn these people in. So people were getting, $5,000 in Afghanistan is a lot. The Pakistani intelligence service was rounding up people, and selling them to the Americans for $5,000 a pop. If you ever want to read an interesting book, you can read a book by a German Turk who was sort of captured and sold for bounty by the Pakistanis. His book is called 5 Years, an Innocent Man or 5 Years in Guantanamo, an Innocent Man. Something about 5 years and an innocent man in Guantanamo are in the title. So once all these people start getting brought in, U.S. interrogators, they've never worked in a context like this. No one speaks most of the languages in Afghanistan. They're relying on, Afghan interpreters. They don't know what they're looking for. So what happened was literally every non-Afghan, everyone, every Arab, anybody who was not Afghani, who was picked up in either Afghanistan or sold, picked up somewhere from Pakistan, sold to Americans, was sent to Guantanamo. Guantanamo was created in the way in which we know it now as a place that would be far from the hot war zone where people could just be subjected to weeks and months and even years of interrogation. Because the United States didn't know what it wanted. So they literally thought the human beings were like the raw material they could put into the grinder of their interrogation machine and eke out the paste of actionable intelligence. So, I mean, that's one of the ways in which it happens. And in Iraq, even more so, when the United States decides to invade Iraq, and Bush, of course, announces in May of 2003, mission accomplished, two months after, the original invasion. And then you start getting, all these kinds of attacks occurring. They're panicking because they sold, the Bush administration had sold the Iraq War to the American public as a necessary good, going to be a cakewalk. Iraq's going to be turned into a democratic country, and then all the other countries in the Middle East will fall like dominoes. And it wasn't working out that way. And so it was the desperation for information, like who's bombing us, that led to sort of the incredible abuses that took place in Abu Ghraib. And so you just get these kinds of, sort of movements. So, I mean, in a sense, thousands and thousands of people were rounded up. Not all of them ended up in Guantanamo, not all of them ended up in Abu Ghraib, but there were I think the estimates might have been 30,000 people were arrested, interrogated, and detained by the U.S. 130 of them were disappeared for years in CIA black sites and extraordinarily rendered to other countries and so on. So it was, to the extent that if this, and if the future administration, sees the deeply flawed and utterly ineffective policy as the model it wants to go with and wants to amp it up even more, I would say there would be great cause for alarm for people, in many contexts around the world.
Did the American Psychological Association formulate an opposition ethical about professional ethics? I vaguely remember that this occurred against, psychologists themselves participating in various levels in formulating techniques for carrying out torture.
Yeah.
Is that, am I remembering accurately? If so, what happened?
Yeah, okay, so the American Psychological Association has been at war with itself, over this period. So, from my understanding of it, psychologists of all the disciplines, like medical doctors, psychiatrists, and other kinds of fields of technical professional expertise, psychologists have been, as a field, have been the most closely cooperative with the military. In other words, there's a whole, large numbers of military psychologists who would do these. But in the war on terror, you get these people sort of being utilized. Meaning Guantanamo, the acronym was BISCUITS, the Behavioral Science Coordinating Tech. I don't know what the C and the T stand for, but they would bring these, psychologists in to be observing these prisoners, figuring out what their weak spots were. This guy's afraid of the dark, so let's keep him in the dark. This guy misses his mother, so let's do things. This guy, whatever it was, the psychologists that were working with the military, and then of course people like Jessen and Mitchell, were very much feeling like their job is to put their professional skills at the service of the state. We're at war. It was utterly different than the positions of the psychiatrists and the doctors, the American Medical Association, American Psychiatric Association. As it becomes revealed, and by the mid 2010, that period, that the big role that psychologists played, and particularly Mitchell and Jessen, the American Psychological Association literally goes to war with itself. There were psychologists formed, the anti-torture group formed the Psychologists for Social Responsibility, and they battled the, it wasn't so much the pro-torture wing, but the wing that was our services, our skills are of value to this nation, and we are not going to take a principled, high-minded stand that we're not going to allow our people to do this. So there's fabulous debates of these kind of things going on between psychologists. If you go back to, sort of the archives of democracy now, you can see some of these. They finally passed a resolution about a year ago, after the Senate, torture report, the executive summary came out, and it was revealed the extent to which, I mean, there were things that were revealed that people hadn't even known before that, and more details about Mitchell and Jessen's role and the way that they use their psychological training. So I believe this American Psychological Association did, by a narrow margin, pass change their rules or something, and the rules were something to the effect that psychologists are no longer allowed to even be, as a matter of their professional code of ethics, even be in a place where prisoner abuse is going on. Now, all the kind of military psychologists have been trying to push back and fight back against it. So it's not like it's this hegemonic, happiness within the Psychological Association, but I believe that they have shifted. I mean, like the balance of power has slightly shifted to impose these new rules that would make it professionally unacceptable, in other words, by the codes of the profession to do what had been done in the previous 15 years.
So I'm kind of interested in the fact that this is really difficult information to digest and to want to listen to. And I was wondering how, I guess maybe this is a more personal question, but how do you educate people on this topic in a way that is palatable to a crowd that doesn't want to hear it?
That's a good question. I mean, I don't have an answer for that. I mean, I'm, one of the things, and this is also very personal, especially I thought about it after the most recent election, it's I'm so glad I'm a college professor, because I have people to talk to to deal with this. If one had to go out into the real world that, I hardly ever venture into, I don't know. But I mean, I guess one would say, think about this. I mean, if you find anything persuasive about the argument that this may be the new abolition movement, think about how the abolitionists had to, what was it like to have to argue against slavery in the 1810s? There's a lot of very interesting books being written and done. I mean, one of my favorites, not even about slavery per se, but King Leopold's Ghost, which very much talks about, it's really the birth of, as he narrates it, the birth of humanitarianism, which was these people focusing on what was happening in King Leopold's Congo and the kind of brutality. And it really narrates in a very detailed way how some leaders just kind of take control of, of building a narrative in a certain way of bringing people to, to be persuaded. I don't think everybody can do everything. I think that in some ways, some people, sort of uncover, the investigative journalists uncover information. The academics might analyze the information, disseminate it. The National Religious Committee Against Torture has been doing, heroic work over. I mean, it's an ecumenical organization that's been, for years, doing information outreach to people who believe all those different religions that are under the auspices of that group. So I think it can never be seen as a singular battle, and it just becomes a question of that's why I would say that it would be a lot easier to make for people to just make arguments if we had more information in the public domain, in a sense. Not to say that there isn't already a lot of information, but, every now and then, certain kinds of information just sometimes have a tipping point effect, so.
Also, I'm from Santa Barbara. I love Santa Barbara.
Okay. Anyone else? Okay, well, I think you guys probably all need to go home and relax after a hard week. But thank you so much for coming.